Welcome to the first in a three-part series of expert talks focusing on patent portfolio strategy. My name's Ian Jones. I have a background in pharmaceutical research and I'm a chartered UK and European patent attorney at Gill Jennings Every in the chemistry and life sciences team. The patent lifecycle can be split into three parts. The first is preparation. This looks at preparing your company for its IP journey. It provides a set of fundamental processes that you should consider implementing to help capture innovation within your company and ensure that your company achieves its commercial goals. Next, there's the implementation phase. These are processes and strategies used to generate registered patent rights. The final section looks at monetization. At the end of the day, this is what it's all about. Part 3 of this series looks at common ways to generate revenue from your IP to make it work for you. But this session is going to focus on the first part, preparation. As a starting point, it is important to think about the relationship between patents and IP in general and your business plan. It is easy to think of patents in isolation as a box-ticking exercise, perhaps to keep directors or investors happy. However, doing so greatly reduces the likelihood of generating revenue from them and potentially exposes your company to risks from competitor IP. Instead, intellectual property, and in particular patents, should be an integral part of your company's business plan. This mind map examines a lot of the key considerations of a general business plan. The top left portion deals with intellectual property. However, aspects of IP are present in most of the other areas. For instance, looking at the research and development wing, patents and their ownership will be an important consideration when collaborating with others. If you're outsourcing research, such as to a custom research organization, you will need to ensure there are the necessary clauses and agreements that pass the IP back to your company. A business plan should also consider your competitors' activity. What IP rights do they have? And how are you mitigating the risks associated with those rights? We're not covering freedom to operate in this series of talks, but it's important to distinguish between your invention being patentable and you being able to work it yourself. A patent is a negative right. It means you can legally prevent others from using your invention. However, it doesn't mean you can carry it out yourself. For that, you need to check that you're not infringing a competitor's IP. So competitor analysis, and in particular monitoring of their IP, is an important consideration. Patent costs should also feature in your company budget. As your patent portfolio grows, so too will your IP costs. Failing to set an IP budget means you may end up spending more than you need. Sticking to a realistic budget will ensure you get cost-efficient patent coverage for your commercial products. So intellectual property is a fundamental aspect for your business plan. And therefore, having the right patent strategy is important to the success of your business. To underline the importance of a patent strategy, think of each patent as a chess piece. Each piece has its own value, but no matter how many pieces you have on a board, you're not going to win unless you have a strategy for using them. And just like in chess, you need to constantly assess and amend your strategy in view of what other people are doing around you if you're to win the game. Having a process for capturing innovation in your company is a good starting point. The aim of innovation capture is to identify, record, and assess innovation going on within your company. It can be a relatively straightforward process started by you or your team by simply writing down what you have been doing. Include a background. Why are you researching this area? What's the problem you're trying to solve? Be specific about your innovation. How does it work? What is it that you are doing that's different to others? And what are the advantages that are linked to these differences? This will be important when we come to put together the inventive step story for your application. And think about what other people in the field are doing. Having a list of publicly available documents will be useful when it comes to drafting the patent drafting process. It's also important to know what you've made public about your own innovation as well. You also need to think about how you intend to commercialize your invention. Who are your customers and where are they going to be located globally? This will feed into the filing strategy, which we'll discuss in part 2 of the series. Finally, you need to think about who created the invention and where was it done. This is important to know because in some countries, they require patent applications to be filed at the local patent office if the innovation was made in that country. For instance, US law typically requires a US patent application to be filed first if the invention was made in the US. The UK, on the other hand, requires patent applications to be filed in the UK first, only if the invention relates to military technology or technology that may be prejudicial to national security. So the questions you want to ask yourselves in innovation capture really boil down to the who, what, where, when, how, and why. If you're able to answer those, then you're well on your way to a suitable innovation capture process. Your research teams need to be aware of this innovation process. And you need to have suitable triggers in place to remind people to do it. This can be as simple as a reoccurring item on a meeting agenda. You'll also need to decide when to involve your commercial team. The commercial team will help focus on marketable products, which in turn will help drive future revenue. In any case, you'll want to involve someone with an IP background, either an in-house person or more likely an external patent attorney who will give you invaluable guidance on patentability and be able to outline exactly what is needed before a patent application can be filed. We spend a lot of time with our clients hosting innovation capture sessions, helping them to identify patentable innovation within their company and putting together a patent strategy for them. One of the innovation capture steps is to identify what competitors are doing. What have they made publicly known? That published information is referred to as prior art and is used in the assessment of the patentability of any future applications. Researchers tend to have a good idea of what's going on in their technical field, the prior art. But most modern publications are behind paywalls. However, there are some excellent free resources out there that can help. Two of those that are patent specific are Google Patents and Espasnet. Espasnet is run by the European Patent Office. Both of these resources allow you to search the contents of patents and patent applications from a wide range of countries to give you a better understanding of what's going on in your field. And both of these search platforms allow you to freely download patents and patent applications. You can also consider a visit to the British Library, although some publications are only available on request, so be prepared before you attend. You can search for patents owned by your competitors, or alternatively, you can use the search to identify new competitors in your field. As we saw on the business plan slide, knowing competitor IP is an important step in understanding your company's freedom to operate. Now, it's a great idea to start with some basic patent searches yourself, but there is a danger to jumping to conclusions based on what you find. Based upon the prior art, it's sometimes easy to believe that your invention is unpatentable, but this is not necessarily the case, and you should always have an experienced patent attorney review the search results. But at this stage, you're really only looking to identify the relevant prior art. So that covers searches that you can conduct yourself. You can consider formal searches. Dedicated search firms offer a variety of searches. They conduct novelty-only searches, which look for specific disclosures within a proposed claim covering your invention. You can also look at having state-of-the-art searches or patent landscape searches done. These types of searches will find surrounding prior art and can be useful in assessing the inventiveness of your innovation. But they're quite costly, and therefore they're usually reserved for projects requiring larger investment, both in terms of financial investment and also time. Patent offices also offer searches, and they're usually extremely good value for money. The drawback is you need to have filed a patent application before you can have it searched by a patent office, and there's the cost of that to consider too. They also take a bit longer to get your results back to you, typically taking between 6 to 9 months to issue them. And that 6 to 9 month period has a certain significance, which you'll see in part 2 of this series, which looks at filing strategy. In any case, these third-party searches, be it by a search company or by a patent office, are useful for due diligence, particularly if accompanied by a patentability report from a reputable IP firm. They're of interest to potential investors and research partners, which can lead to additional revenue streams to your company at an early stage. The last aspect of the preparation phase of the patent lifecycle looks at ownership, and in particular, your company's IP policy. Now, innovation capture identifies the inventors. This is important not just from a first filing point of view, but actually because the inventors are the legal owners of any resulting patent rights. But you obviously don't want those rights you obviously want to move those rights to your company as soon as possible. Under UK law, if an employee is paid to invent things, then the rights to the patents automatically transfer to the company. After all, they're being paid to come up with the ideas for the benefit of the company, so the company should be able to benefit from the IP. Senior roles in companies, such as directors or board members, may also have a special obligation under UK law to further the interests of the company, and so their patent rights might automatically transfer too. However, this doesn't happen in a lot of countries, and so you may need the rights to be formally assigned from the employee to the company. This is a relatively simple process and requires just a few signatures, but it needs to be remembered and it needs to be done. Notwithstanding the ability to formally assign rights, it's highly recommended to include an IP clause in employee contracts, which states that the IP rights that originate from their employment will be solely owned by the employer. Researchers are typically accepting of these clauses. Once the rights are with your company, you need to consider where to store them. Most SMEs will retain them in the core company. However, there are certain benefits to shifting the rights to an IP holding company, such as the ability to ring-fence your IP assets and protect them from trading risks. There are certain other tax benefits which may be useful as well, such as the royalties paid to the IP holding company may be deducted from your company's income tax base as operational costs. So this brings us to the end of this first session. We've explored the preparation part of the patent lifecycle and introduced a number of processes that you can implement at your company to capture and capitalize on your innovation. Part 2 in this series will focus on the implementation strategies.